Welcome to the 30 Years, 30 Cases, a series of the Academy of European Law era. I'm Sanja Jovicic, and I'm a senior lawyer at the Academy in charge of fundamental rights training. In this podcast series, we will be speaking about the Court of Justice of the European Union opinion number 2/94 concerning the EU accession to the European Convention of Human Rights and Fundamental Freedoms. The opinion was delivered in 1996. At this time, the negotiations of the agreement for accession of the community to the convention had not even started yet. The court noted back then that no EU treaty provision had conferred on the community institutions any general power to enact rules on human rights or to conclude international conventions in this field. Therefore, community law as it stood then gave no competence to accede to the convention. We are discussing this case today with Tobias Locke, professor at Maynooth University and Jean Monnet Chair in EU Law and Fundamental Rights. Tobias' research and teaching interests are in European law and human rights law. He's mainly interested in the interaction between different legal orders. Recently, he has focused much of his attention on the legal question raised by Brexit. Tobias retains a keen interest in the Court of Justice of the European Union, the EU Charter of Fundamental Rights, and the European Convention on Human Rights. Professor Locke, thank you very much for joining us today. Could you please explain what were the legal implications of opinion number 2/94?
Well, there were three main points that should be made about opinion 294. So it had three main consequences. The first is obviously that the EU did not at the time have competence to accede to the European Convention on Human Rights, which then resulted in treaty change in what we can now see as Article 6.2 of the TEU, which gives that competence to the EU. So that's the most immediate consequence of Opinion 294. But there are two other important things that Opinion 294 did. One was it contains a fairly broad interpretation of the admissibility criteria for the advisory opinion procedure, the procedure laid down in Article 218, paragraph 11 TFEU. And secondly, it contains an important clarification of the limits of the flexibility clause or gap filling clause, which is now Article 352 TFEU. That is a clause that allows the EU to act, to have competence internally and also externally, where it is necessary for the Union to attain one of the objectives of the treaty. So it's a potentially very, very broad competence space. The Court of Justice made it clear that that cannot be used to circumvent the allocation of competences in the treaty itself and to circumvent the principle of conferral, which is the very basis of EU action in external and internal affairs. So those are the headlines, the 3 points about Opinion 294. Now, the opinion was criticized by numerous academics, not so much for the admissibility decision, but for its substantive decision about the EU's lack of competence to accede to the ECHR. And that criticism is really, on the one hand, is a doctrinal criticism of the interpretation of Article 352, which I believe most academics who were commenting at the time, broadly speaking, shared. They do accept that Article 352 cannot be used as some sort of a competence to create a new competence for the EU. But what they criticize about the court's decision in this regard is that the court's reasoning was not particularly convincing. Now, as you mentioned, Sanja, at the time, the EU had not engaged in any negotiations with the ECHR. There was no draft agreement, there was nothing. There was just the question, can we, in principle, sign up to the European Convention on Human Rights? And the Court of Justice acknowledged that, and it said, well, we're not talking about the substance here, we're only talking about the question of, can the EU in principle accede? But what the Court of Justice then did is it said, look, there are limits to the use of Article 352 TFEU. We can't make any moves of what the court called constitutional significance. which was a new concept, wasn't quite clear what constitutional significance meant. One could guess that it means that the EU needs to go through the treaty amendment process, Article 48 TEU, rather than base its action on Article 352. But why was it that the ECHR accession would be of constitutional significance? That is something that didn't become so clear. The opinion is very, very short. It's only 36 paragraphs. Now, by today's standards, if you look at similar opinions, they will run into the hundreds of paragraphs. So, it's a very, very brief piece of writing. And the substantive issues is only a handful of paragraphs, 8 or 9. So the argument was that all the provisions in the ECHR would become an integral part of the EU legal order. But that was in 1996. And in 1996, there had long been case law, a long-running case law by the Court of Justice that had accepted that there were fundamental rights that were so-called general principles of EU law. And for a long time, the Court of Justice had based these primarily on the ECHR. So that wasn't a really convincing argument. The actual reason becomes clearer when one reads a bit more closely. And if I quote from the opinion, such a modification of the system for the protection of human rights in the community with equally fundamental institutional implications for the community. So the Court of Justice mentioned institutional implications for the EU that would flow from the accession to the ECHR. And what it seems to mean is that there would be an issue about coordinating the jurisdiction of the two European courts, the respective ones. So who would decide about these human rights violations? Who would have the last say? Is it the Court of Justice or is it the European Court of Human Rights? And under what circumstances, how would they relate to one another? That's certainly before the background of the fact that the Court of Justice had already established that it has exclusive jurisdiction over EU law matters. It was only a few years before that in opinion 291, and that there was such a thing as the autonomy of the EU legal order. Now, the Court of Justice doesn't mention any of this, but that seems to be what it means. Now, obviously, that contradicts the fact that the Court of Justice actually said that it didn't want to decide about any of the substance of EU accession, just about the competence. But what it actually does is that it engages with a putative accession agreement and says, well, such a putative accession agreement would be so far-reaching, would require so many adaptations and adjustments, and maybe even restrict our own jurisdiction, that this would need treaty change and cannot be done on the basis of the current version of the treaties as they stood in 1994 when the opinion was requested. So that seems to be the gist of the argument of the Court of Justice, and that also was criticized because it was seen to be a bit contradictory and also not particularly convincing when it comes to the question of competence only. Where the admissibility is concerned, that broad reading of the admissibility criteria in Article 218.11, that is still very much the case today. The Court of Justice, I think, in my view, rightly said we have to accept requests for an opinion, even if there is no draft agreement, even if there are not even negotiations anywhere going to happen in any likelihood anytime soon. Because what's the whole point of the opinion procedure? It is to prevent the EU from signing up to treaties that are contrary to the EU treaties, so that the EU would find itself in a situation where it was bound by an international agreement, which it cannot fulfill because of constitutional limitations under the EU treaties. And therefore, these opinion procedures have to be, the Court of Justice has to be fairly generous about accepting these requests for an opinion. And obviously, we had a request by an EU institution here, so it's a fairly important body in and of itself, and therefore the admissibility decision, I think, was fairly uncontroversial. By contrast, the decision on the substance was not particularly welcomed in academic circles, and but nonetheless had huge implications because it resulted in the need for treaty change, which we then got with the Lisbon Treaty.
In 2013, the court was called to adopt a second opinion, number 2/13. By then, the Charter of Fundamental Rights and the Treaty of Lisbon entered into force, setting more detailed provisions as to the EU accession. However, the Court of Justice again found many issues left open. The absence of consideration of the specific characteristics and the autonomy of EU law, the possible European Court of Human Rights findings as to the scope of EU law, lack of arrangements for the operation of the correspondent mechanism, and the procedure for prior involvement of the Court of Justice, and failure to have regard to the specificities of the review of EU common foreign and security policy. Professor Locke, do you think that the Court of Justice closed the door to accession in this opinion? Was this really a question of constitutionality, or there was more a misunderstanding of the role of the European Court of Human Rights and the Convention complaint mechanism?
Yes, in opinion 213, the court was again asked to decide about the EU accession to the ECHR. I mean, this time we didn't have a question of competence as such to decide, but what the court had to decide was whether the draft accession agreement, which was put before it, was compatible with the EU treaties. So there was an agreement following long negotiations, and it was fairly detailed. And the agreement really, most of the problematic parts really tried to address issues about the autonomy of the EU legal order. So the autonomy of the EU legal order is a concept that was long ago developed by the Court of Justice, which says essentially that the EU can sign up to international agreements, but it must make sure that no other court is given jurisdiction to decide upon the interpretation of EU law in a binding manner on EU institutions or member states, or on the division of competencies between the EU and its member states. And the negotiators of the accession agreement tried to address those issues, but the Court of Justice still found fault with what they had done. And really the centerpiece of the accession agreement and the most important provisions in it deal with questions about the allocation of responsibility after EU accession. So you have the following problem where obviously the EU would have signed up and become a party to the ECHR, but the member states would have remained parties to the ECHR. So what happens if, in a hypothetical example, you have an individual who brings a case to the European Court of Human Rights complaining of an Article 3 violation, a violation of their right not to be subjected to inhuman and degrading treatment or punishment because they have been in jail in a member state in prison conditions that have been so bad that they amounted to inhuman or degrading treatment or punishment. Should that member state be responsible for this, or might the EU also have to be brought into the case? Why might that be the case? Well, a member state may arrest somebody for purely domestic law reasons because they may have committed a crime under domestic law, and they may have been convicted and sentenced to a jail sentence. A member state may also arrest somebody on the basis of EU law, following a European arrest warrant. So if the latter is the case, should the EU be the true respondent in these proceedings, or should it still only be the member state? And if it is the EU alongside the member state, how do we decide that a case is appropriately brought against the EU and a member state, or that it is appropriately brought just against the member state? So that requires us to look at EU law, that it requires the European Court of Human Rights potentially to look at EU law. And this has to be avoided in order not to violate the autonomy of the EU legal order. So what the negotiators did was they introduced the so-called co-respondent mechanism. They also introduced a mechanism for ensuring the prior involvement of the Court of Justice in cases where the EU is brought into the case, but where the Court of Justice has not had a chance to decide on the matter itself. And both of these fairly technical mechanisms and solutions were, on the one hand, designed by the negotiators to avoid problems with the autonomy of the EU legal order. But on the other hand, the Court of Justice then said, well, look, I mean, nice try, but you didn't quite manage, because there were some issues with them. And these issues were about possibilities of review by the European Court of Human Rights. The European Court of Human Rights was given the jurisdiction to review the plausibility of any co-respondent request. It was also given the jurisdiction to decide whether the Court of Justice had been involved in the first place or not. Both of these things said the Court of Justice need to be left to the EU institutions, and the ECHR must not have any jurisdictions over them. Now, there were a few other technical issues that the Court of Justice took issue with in Opinion 213 related to inter-party applications, related to other relatively easily resolvable issues, coordination with Protocol number 16, coordination between the two Articles 53 in the Charter and in the ECHR. But there are two hurdles that are very, very difficult for negotiators who are currently negotiating a renewed accession agreement. Two hurdles that are very, very difficult to cross. One relates to the mutual recognition principle, mutual trust principle in EU law, which needs to be preserved, says the Court of Justice. And the other relates to the common foreign and security policy, where the Court of Justice only has very limited jurisdiction. Now, on mutual recognition, mutual trust, this requires member states to trust the fundamental rights protection more or less unquestioningly in other member states. There are some exceptions in the case law of the Court of Justice, but the Court of Justice says member states cannot generally be forced and be asked to check whether another member state has complied or is in compliance with the ECHR. And if EU accession to the ECHR results in such a duty, then it's not compatible with the EU autonomy of the EU legal order. So that's a difficult one to resolve, because you need to write a legal text that, on the one hand, balances the need for efficient and effective human rights protection, which is the whole point of EU accession, and on the other hand, making sure that member states are not forced to violate their duties under EU law, viz. Their duties to recognize each other's fundamental rights standards in most cases, except for exceptional cases. But how do you formulate a provision like this without, again, inviting the European Court of Human Rights to decide on matters of EU law when it comes to it? The other issue is the CFSP. Now, the Court of Justice only has limited jurisdiction in this area, mainly about sanctions and about the delineation of competencies between CFSP competences and regular external competencies. Again, the Court of Justice says, okay, if a case comes to the European Court of Human Rights, which alleges that a CFSP measure over which we don't have jurisdiction has resulted in human rights violations, then we need to be able to check first whether this is compliant with EU law. It cannot be that the European Court of Human Rights is the first court to look at these matters without us having any jurisdiction. There has to be a parallelism in jurisdiction. How to resolve this, I don't know how that's going to be done. It's a very, very difficult issue for the negotiators, again, to find a formulation for this accession treaty, for this accession agreement, which does not in itself give the European Court of Human Rights any power over deciding what is CFSP, what is not CFSP, and so on and so on. So again, something that doesn't interfere with the jurisdiction of the Court of Justice. So these are the challenges that Opinion 213 presents to those currently negotiating the EU accession to the ECHR.
What is to be learned from these cases, and what developments do you expect out of them?
Well, what is to be learned from the cases is that you just never know what the outcome of an opinion request is going to be, and that the autonomy of the EU legal order is something you have to take very, very seriously when negotiating any agreement if you're an EU negotiator. What will be the long-term impact? I think the long-term impact of the cases has become quite clear. Opinion 294 resulted in treaty change. Opinion 213 resulted in renewed accession negotiations. They will probably be finalized, I would guess, over the next year or so. And then we'll have another opinion on the same matter, we can be sure. So EU accession to the ECHR is a never-ending topic.
Thank you very much, Professor Locke, for joining us. This is the end of our podcast. I invite our viewers to check out other interesting discussions within this series covering a huge amount of few law-related topics. This was ERA's 30 Years, 30 Cases podcast series.